I'm Drew Stevenson. This is a lecture about the case U.S. versus or United States versus Florida East Coast Railway Company, a U.S. Supreme Court decision from 1973. I teach this case in two of my classes, in administrative law and in statutory interpretation and regulation, or Leg-Reg. And so it's a very famous case that sort of set some important precedent in the area of law that governs how regulatory agencies can make rules. In my administrative law casebook, this is under the heading of federal statutory hearing rights. Now, a quick word for my students. This is a longer, more complicated case. The opinions in our casebooks are usually edited and redacted a lot and don't fully explain the problem here. But in administrative law, or anytime you're reading about regulatory agencies, you should ask yourself, like, what is going on here that was worth it to the parties to litigate? What were the stakes here? Who was aggrieved? And what was the agency, and what's our enabling statute? And so I'm going to explain that. The other thing that's important about this case is its reliance on a couple of previous cases, which it synthesizes into sort of the new rule. And so I'm going to spend some time explaining that and have a little diagram at the end. So bear with me here. Let's look at what happens with the Florida East Coast Railway. And I'm going to start with some main takeaways for you, because I'm afraid that some students are going to give up on me or get tired of this, because the subject matter, trains are interesting, but the subject matter is a little boring, and the agency at issue here doesn't even exist anymore. But under its enabling statute at the time, the Interstate Commerce Commission had the power to regulate railroad freight car rates, and among other things. So the commission, here's the quote from the statute, and this is either put in a footnote in the opinion, if you have that, or put in brackets, kind of summarized for you. But here it is: the commission may, after hearing on a complaint or upon its own initiative without complaint, establish reasonable rules, regulations, and practices. And then it goes on and on. And the Supreme Court, here again, we're still focused on like kind of the spoiler here, held that this phrase, after hearing, really just means the type of notice and comment rulemaking or paper review that's required by APA Section 553 for informal rulemaking. That's what we call it in administrative law. And did not mean a literal hearing with oral arguments or formal rulemaking procedures, which are trial-like proceedings on the record under the APA. And also note, as you kind of dive into this case, that the ICC actually had held some meetings, or what could have been called hearings, but the railroads wanted more because they didn't like the direction that this was going. Now, also in terms of your takeaway here, after this case, for practical purposes, an enabling statute must include the phrase "on the record," or with hearing, or some express reference to APA formal rulemaking and formal adjudication procedures that are set forth in the Administrative Procedure Act 554 through 557. Otherwise, if it says after hearing, after a hearing, after with hearing, or something like that, similar phrases in a statute will usually mean nothing more than a review of document submissions. And in other words, the functional equivalent of notice and comment rulemaking. And now I'm going to explain what was the big problem. What do we mean about rail car rates and rail car shortage? This is from a Time magazine article in 1966, right before this litigation started working its way through the appellate courts. In the Midwest, mountains of grain lay aging in elevators for lack of boxcars to move this stuff to market centers. In other words, there weren't enough train cars to get the harvest shipped to the coast. And we actually had we've had this happen. This is a recurring problem throughout the 20th century and into the 21st century with the boxcar shortage, because of the weird incentives that railroads have. And so at least 15 lumber mills had to shut down temporarily because of their production was far outdistancing their ability to transport the lumber to market. And because plywood plants could not ship, the price of standard grade plywood, which of course is used in houses and constructions, has jumped by more than 1/3, from 62 per thousand square feet to 86 in 2 months. This meant, I want you to look at this quote for a moment and think about that this means this is affecting consumer food prices. So if the mills aren't getting the grain from the Midwest, that means the bread in the stores and the boxes of cereal and so forth consumers are going to see prices start going up and shortages and maybe even bare shelves. And then when plywood prices go up, that means that home prices start to go up, and home renovation and other types of construction things start going up, and people start calling their congressman. So the US railroads at the time owned about 600,000 boxcars. By the way, it's now a fraction of that in the years since 1966. But they were retiring 30,000 cars, more cars a year than they are replacing. And beyond this rate of attrition, there's an even bigger reason for the boxcar shortage, which was a bizarre sharing arrangement between the railroads. As a quick aside, I'm going to come back to this. I want you to understand, those railroad cars, the freight cars, are expensive. And based on my limited research, it seems like they're about the price and throughout the last few decades of a starter home. And so nowadays it might be around $150,000 for a small home in the suburbs, and that's the price of a boxcar, of a new boxcar. And in the 60s, it was $25,000-$30,000 for a new boxcar, which was what you might get a little like Cape Cod house as a starter home in the suburbs for. And so that's a lot of money, and the railroads, that's a lot of cash up front. And if you think about it as a railroad, if you are not doing so well or operating on a thin profit margin, that's money that you can't use to expand your track lines, right? So if you are having to make a business decision, should I lay down more track and expand my routes, and what the opinion insists on calling roads for some reason, but we mean railroad tracks, or should I buy more cars? It's always going to seem like putting down more track or expanding where you run your line or building a new stop or things like that are going to take priority. And so that was part of the problem, is that the boxcars are expensive. Also, under federal statutes, there's a mandatory retirement age for freight cars at 50. And so when a car is 50 years old, they get pretty banged up, right? Because if you think about lumber and coal and grain, it's just kind of being thrown into these, and then they run across the country in the open air. And so by federal statute, you have to replace them. You can't use one that's more than 50 years old. And the railroads don't have an incentive when they have to stop using a car to go buy a new one, because it's a big out-of-pocket expense all at once. And so what happens is the number of cars on the tracks goes down every year, and has for decades. And this means that there's really, in some times of the year that we don't have a crisis, but during, let's say, harvest time, when all of a sudden the farmers in the Midwest need to get their goods to the ports, they need all the cars in the Midwest to load them up, and there's not enough cars. The other big piece of this that's really what led to this litigation is the railway companies have their own trade association called the Association of American Railroads, and that ends up creating a problem here. So under this association rules, they have a sharing agreement. All lines have to lend their boxcars to other companies if the demands of traffic so require. In other words, if you look at a map, the Florida East Coast Railway is a rather kind of short line that just runs up the eastern seaboard of the state of Florida. And so imagine that you're shipping a load and people want to get their stuff up to Washington, D.C., their goods, or Boston or New York City. but your line stops at the Florida border. And so what are we going to do? Well, we could unload your entire cargo and reload it onto a train, but by before the year 1900, the railroads realized that was too much of a hassle, and instead they should just attach the cars to the next line and keep the train going. And so that's what they would do, is they have a switching yard, and when one train's line stops, there's usually another train a train line that picks up there, and the cars just get hitched up to a train and they can keep going. And so, but that means that that the original cars are now running on a different railroad's track. And so if I can bring back your childhood memories of playing Monopoly, we had the B&O Railroad and the Reading Railroad and the Pennsylvania Railroad and the Short Line Railroad. And you want to be able to run your cars on every railroad's tracks. So if you keep it, so basically you had a free lending agreement between them. And that also meant that once it gets to its destination, the railroad can, and those cars are emptied at the port, they can be loaded up with a different load for shipping back south or east and west and so forth. And you can do that for free. So let me ask you, if you're running a railroad, are you going to buy new cars when you could just use other railroads' cars for free? No way. So, but this is sort of a tragedy of the commons that, and in an earlier case, a Supreme Court case, Justice Rehnquist, that he refers to in this one, that he explains this in detail and explains that the way the association worked meant that all of the freight cars in the country had become a common pool. And then this created a tragedy of the commons problem, where every railroad had a perverse incentive not to buy any new cars and just use the other railroads' cars for free. And if you kept a boxcar for a long time, you might have to pay a very nominal daily rental fee of something less than $3. And again, think about the fact that buying a new car is going to be the price of a home. And so if you want to keep a car for a month or two on running on your tracks, you only have to pay less than $3 a day. And that rate hadn't been going on. This case is also interesting, by the way, because we have a private sector a remedy attempt to address a market failure, a tragedy of the commons. We have a classic market failure in operation here, and the trade association's solution was also not working. So here, I'm going to continue with this little excerpt from the Time magazine coverage of this. The Western railroads were getting the worst of this arrangement. In the US, the heaviest flow of bulk product rail traffic moves west to east. Remember, our big port cities at the time in the mid 20th century were New York, Boston, and so forth. And as Western states ship their grains and other raw materials eastward for finishing. And once a Western-owned boxcar arrives in, say, New York, an Eastern operator simply takes it over and keeps it. And then they pay this token price, this nominal rental fee dictated by the Association of the American Railroads. And so the Western railroads never get their cars back. So the two lines currently hardest hit by the system were the Great Northern, which owned at the time 22,800 boxcars, but has only 48% of that number on its own tracks in 1966. And the Northern Pacific Railroad, which owned 20,000 boxcars and only had and it only had 60%, 40% of them were just being kept by East Coast railroads. And so now let's get into the case. At the time of this case, the Interstate Commerce Commission, or ICC, which, as I said, no longer exists, had the power to regulate railroad rates. And the enabling statute said the ICC should set the rates after hearing. And the ICC was being pressured by Congress because, again, the harvest was rotting in the silos, and the lumber mills were just having to shut down because they couldn't ship out the stuff they were producing. They began proceedings to set a new rate schedule that might solve this chronic shortage of freight cars. The ICC apparently thought at the time, the officials there, that they were required to use formal rulemaking, probably because of that phrase in their statute. So they started compiling reports and having meetings with reps from the railroads and gearing up to do this elaborate proceeding that would be on the record. And they had planned to have more hearings. And then they get hauled in before their Senate subcommittee for a really embarrassing, humiliating dressing down. Basically, the Senate subcommittee hauls in the commissioners and demanded immediate results and said, well, look, we've been sending messages to you that you have to solve the railroad car shortage. We passed a new statute giving you sweeping powers to do this, and you haven't done anything. And by the way, this refers back to an earlier issue in the course, after our discussion of the non-delegation doctrine and things like that. There's some mention in the notes about how these committees and subcommittees have a sort of an unquantifiable amount of influence over the agencies and control. But this is something agency officials, they don't like, and they're worried. They're worried that they're going to get defunded, or that their enabling statute is going to get changed in the next session of Congress. And so when the senators call them in and say, we want this fixed yesterday, the ICC officials come out of the hearing in a rush to resolve things. And so they invoked an exception under formal rulemaking provisions that's found in APA 556D. We don't spend a lot of time on this in class, to skip oral hearings. And it turns out that this was unnecessary after this case. But for my students, when you're in practice, even if you have formal adjudication or formal rulemaking, I hate to oversimplify, but there's an APA equivalent to a motion for summary judgment that the administrative law judge or a commissioner can invoke sort of in their discretion, and you file a motion to ask for that, to basically waive oral hearings. But the commission then told the railroads, go ahead and send in your comments on the proposed schedule within 60 days. The railroads were really unhappy. They kind of, you got to remember, they liked this. We get free rail cars and we don't have to pay out of pocket for them. And we're just using everybody else's, and they can't charge us more than $3 a day. And so several railroads formally requested oral hearings anyway, and the ICC rejected their requests. And so the railroads also submitted some written objections to the rate schedule. And the ICC rejected most of the railroad's objections and adopted a new rate schedule with slight modifications. Basically, you're going to have to pay more if you hold on to another railroad's cars. And they were trying to create, first of all, a way to punish railroads that were hoarding all the other railroads' cars, and also to incentivize a railroad or maybe even a third party to make the cash investment for new cars, because you're going to get paid more when you rent them, lease them essentially to other railroads. And that this was, the ICC said this is effective immediately, and the railroads sued. And the lower courts held that the ICC should have followed formal rulemaking procedures under APA 556 to 557. This involves lengthy hearings and so forth, based on the statutory requirement that rate decisions be made after a hearing. The Supreme Court rejected this idea and said that after hearing meant notice and comment procedures, which were already satisfied here. The court holds that the APA requires formal rulemaking only when rules are required by statute to be made on the record after opportunity for an agency hearing. And so nowadays, without these words or something equivalent in the statute, agencies can normally use informal rulemaking as their default, even if it says something about a hearing. It really has to use these magic words, on the record, or something like that. And not many statutes do. Only a few federal statutes use the phrase on the record after an opportunity for a hearing, or invoke the formal rulemaking sections of the APA expressly. And the court suggests here in dicta that other phrases might trigger formal rulemaking, but the court has never found formal rulemaking triggered by any other language. And that's part of why this case is sort of a landmark decision that changed the direction that things went from then on. Here's a highlight for those of you who like to highlight things in your case. Find the part where the court distinguished between administrative rulemaking and administrative adjudications for purposes of deciding what level of procedures an agency must use. So for purposes of deciding what level of procedures an agency would use, it really matters whether this looks more like rulemaking or more like adjudications. And I want you to, this sounds nice, and if I was writing it on a board or when I'm making a PowerPoint slide, it sounds like, well, it's clearly one or the other. But in practice, there's some ambiguous situations where we might characterize what the agency is doing as sort of one and sort of the other. Here, there had been no effort to single out a specific railroad. This was going to apply to everybody. So the agency's action was more legislative, more like rulemaking than adjudicative. But remember, that's not completely clear when you're announcing a new rate that everybody's allowed to charge. This also meant, because it's more legislative, that we're not going to bring in due process hearing rights under Matthews v. Eldridge and that line of cases. So here I want to talk about this Londoner-BMI rule that the court talks about. This is closer to the end of the opinion, but it actually really matters. The court invoked its earlier distinction in the cases Bimetallic Investment Company, or BMI, versus the State Board of Equalization, and Londoner v. Denver for legislative versus adjudicative action. And to be honest, some administrative law casebooks actually include these two cases along with Florida East Coast Railway. I expect my students just to know what I'm going to say about them here and what's said about them in the case. Londoner v. Denver, just in a nutshell, that was an individual homeowner's property tax assessment was increased. But it was a one-time tax assessment for road improvements. And this happened in the mid-20th century as cities and towns started to pave roads and put in city sewer lines and city water. That's really expensive. And so sometimes what they would do is, when I grew up in a day when in a town that still had some dirt roads, and a lot of those have been paved in the intervening years. Well, that's very expensive for a local town. And so what they would do is basically demand everybody who lived on that street, now that you have a paved road, we expect you to cough up a few $1,000s, and at least now, or your home value, your home tax, property tax might actually go up permanently. And I've seen both done, right? And I've seen this done when they put in city sewer and water to a street in a remote location and so forth. And in Londoner v. Denver, because this was one homeowner who's going to have to pay more for their own property taxes because of something that was done onto their street, the Supreme Court said that this was more adjudicative, and therefore they deserved kind of a true hearing and oral argument. The BMI case was, they said that there wasn't a hearing required, and this was also about property tax, but basically the state tax officers in Colorado just decided to raise everybody's property tax, and they just increased what we call the mill rate of all taxable property in Denver by a substantial amount. So the people who lived in Denver suddenly had a big increase in their property taxes in 1 year, that a permanent increase. And in that case, the court said, this is more legislative because it affected everybody. We weren't targeting individuals or even the houses on one individual street, which is close enough to individuals. This is everybody that owns a home in the biggest city in the state. And so they said that you don't get a hearing because this is more like just legislative activity. So raising property tax rates for everyone is kind of our prototypical legislative type action. It has general applicability and prospective application, and it's policy-based. So I made a diagram for my students that sometimes I've just drawn on the board. So For purposes of administrative law, when we're talking about whether you are getting a formal hearing with oral arguments, or if we're really going to do something that looks like notice and comment rulemaking, the court asks whether this is a legislative or adjudicative activity. And the way we kind of have three prongs, or a three-part test for this. One is the time. Is it forward-looking or prospective, or is it retrospective? Are we asking what happened in the past? If it's prospective, like from now on, everybody has to pay more taxes, that's more legislative. If it's like what happened to you that you might actually have be the target of an enforcement action, or have to pay a fine or a one-time fee or something like that, that's more retrospective. Legislative rules have general applicability as opposed to just a single individualized effect. And so again, remember in BMI, this was a tax increase for any property owners anywhere in the city of Denver. And in Londoner v. Denver, which was, remember, these are tax cases from people in the same city. It was a homeowner on one street who was assessed an improvements tax, essentially. And then also note that the third prong is what kind of facts give rise to this. So the idea is for legislative rules, we're usually talking about general policy determinations, like there will be a preamble talking about societal problems or the economic impact and so forth. And in adjudicative situations, we're talking about almost your classic journalism class questions of who, what, where, when, how, and why. Or if I can invoke your first year law classes, these are the types of things that trial courts are supposed to address, right? Like who are the parties, who did what really happened, where was it, and when, and what was the intention of the parties, or why did it result, what was the outcome, and so forth. And that's very different than the types of facts that, let's say, the legislature uses in raising taxes, or changing healthcare policy, or changing immigration policy, or something like that, where we're going to talk about big picture things. So why does this matter? Well, if it's legislative, agencies can use informal rulemaking procedures. In other words, notice and comment rulemaking. And if you see that phrase hearing in the statute, it doesn't mean its colloquial meaning. This means based on papers and documents submitted. If the agency's decision or action is more adjudicative, then we might require formal rulemaking, like, in other words, trial-like proceedings on the record, or formal adjudication if they decide this is actually not rulemaking, it's adjudication. And if it's neither one of those, if this is more of a Goldberg v. Kelly type situation where we're, let's say, doing a license revocation or cutting off someone's government benefits, we're probably still going to want to have a fair hearing because of due process concerns. By the way, agencies, I say this in class, and this comes across in the cases and the notes between the cases, everybody hates formal rulemaking under the APA, right? It's just terrible. It's a long, protracted process that's usually not worth it. There's an infamous example of formal rulemaking. That was the FDA's decision at one point to promulgate a rule that would raise the minimum peanut butter and products marketed as peanut butter from 87% to 90%. In other words, I want you to think about that. How many peanuts are actually in the peanut butter that you like at your favorite brand of peanut butter, as opposed to fillers or gelatin or sugar and things like that. And they were just going to raise it 3%. But they were forced, because of their enabling statute, to do this with formal rulemaking, and it took 9 years to raise the peanut content requirement 3 percentage points, including 20 weeks of oral hearings and an 8,000-page record. Would you bother if you were running an agency and it was going to take a decade to make an incremental adjustment in the regulations? Probably not. And that's what happens in practice. So there is a lot at stake here in this question about whether we're going to have formal or informal rulemaking. Okay, that concludes our lecture about the United States versus Florida East Coast Railroad.